the second case on this morning's docket, case number 109806, State of Kansas v. Ford.
May it please the court, Richard Ney appearing for the appellant in this case, Harold Glenn Ford. Mr. Chief Justice, I'd ask for 3 minutes for rebuttal.
3 minutes is granted.
Your Honors, 24 years ago, before his trial was set for on first-degree murder charges, Mr. Ford's attorney told the court, and I quote, "Based on his knowledge and observation of the defendant, there is reason to believe that the defendant may be incompetent." And the court accepted that position by defense counsel and ordered a competency evaluation. And that was the end of it, as far as competency was concerned.
There was an evaluation, though.
I'm sorry?
There was an evaluation here.
There was an evaluation,
And
yes.
there was a report to the court and the parties, correct?
Indeed, yes, Your Honor.
There just was no follow-up hearing that we have a record of.
Well, I think it's pretty clear there was no hearing. Nothing in the record.
There's no entry in the record of action for a hearing devoted to that topic.
Yes,
There are
Your Honor.
hearings, we just don't have any record that it was ever discussed again.
Yes. And I think that makes it clear that it wasn't.
So is your claim here that we have a procedural flaw, or that your client was actually incompetent at the time?
Both.
Okay.
There certainly was a procedural flaw. I don't know that even the state is disagreeing with that position. Nothing was done to determine, there was no hearing to determine the defendant's competency, but there were grave concerns in that report. And if you look at it, at volume 8 of the record, the report itself, one of the first things that comes to the fore is that the psychologist says that the defendant is taking antidepressant medication, which he stated he obtained from his mother, to help control, quote, mood swings and to keep him, quote, very balanced. So he was taking Prozac, but now he wasn't taking it. We know that from the plea because he says he wasn't taking any drugs. But of more concern, on the second page of the report, the psychologist says, Mr. Glenn, he's getting his name wrong, it's of course Mr. Ford, but he says, Mr. Glenn states that it is his desire now to, quote, get on with my life by asking his attorney to make the best possible plea agreement. Well, get on with his life, maybe it was more appropriate to say get on with a life sentence. He's not getting on with his life at this point. But then it says, the best possible plea agreement, which would prevent his spending any further time in administrative segregation while incarcerated. Mr. Ford had been held in solitary this entire time. He was saying to this psychologist, and this should be a red flag to any attorney, I want to plead guilty because I want to get out of the hole. I'm just suffering here in solitary confinement. I'm willing to do anything to get out. Now again, those are some red flags of concern. I agree that the bottom line for this psychologist is that he's competent to stand trial. I, as a defense attorney, would look at this and question that, whether there was a competency to stand trial. So again, when we look at the record too, there's nothing in the record that says anything different than that. There was a plea hearing. Mr. Ford signed some documents. He had a plea colloquy with the court where his longest answer was 4 words. No, I did not. When asked if he had taken any drugs prior to the plea. Most of the answers were 1 word, yes, no, correct. So certainly the court had no sense, and we can gather no sense from that plea of what his state of mind was. But, so Mr. Ford files a motion to correct the illegal sentence. That's heard in 2010. This is 18 years after the filing of the competency request. So if we look at the Davis standards, the period of time that's elapsed is incredibly extreme. But we're looking at the Davis standards only if this court were to say there was a retroactive competency determination. And there wasn't. There was no retroactive competency hearing because there couldn't be one. The competency statute 2232-302 says clearly in section 7, the defendant shall be present personally at all proceedings under this section. Mr. Ford was in a cell back in Hutchinson Prison at the time the hearing took place in September of 2010. So whatever we may call what happened in 2010, we can't call it a retroactive competency hearing. Mr. Ford wasn't there. And if we look at the Davis standards, which Mr. Chief Justice, you enumerated in Davis, one of them is time, but the second is comments that the defendant might have. And I think it would be, certainly would have been helpful, critical in fact, to the court to understand this competency evaluation to what Mr. Ford was talking about, that he was willing to plead guilty to a life sentence because he was in solitary confinement. So, if again, looking at the Davis standards, and I suggest we can't get there because there was no hearing with the defendant present. We look at that, the passage of time, the availability of contemporaneous medical evidence, including medical records and prior competency determination. All we have is this 2-page report in that regard, which, again, I think raises more questions than it does answers. The third standard, any statements of the defendant in the trial record, we have yes, no's, that's it. So there's really nothing to determine competency about. Anybody can get through that kind of plea colloquy. And 4, the ability of individuals and trial witnesses, both experts and non-experts, who were in a position to interact with the defendant before and during trial. We had the defense attorney who raised the initial questions based on his observations and knowledge. And we had the prosecutor, who I would suggest had very limited contact with a defendant. But certainly, when we're saying someone is pleading guilty, as he tells the psychologist, in order to get out of solitary, because it's so horrible, there are some concerns there.
There's concerns about coercion, but that doesn't go to competency.
Oh, I think it does, Your Honor.
How does that go to competency? I mean, that actually is a fairly clear thought, isn't it? I'm in an environment that I find intolerable, and a way to get out is to plea. Is not an irrational thought. It's not an incompetent thought. It's a thought that maybe he's being coerced into a certain situation, but it's not a statement that goes to competency. And if you look at this overall evaluation, it's full of opinions and assessments that your client is competent to stand trial at that time. There's nothing else you can take from this evaluation.
Well, I understand, but I think part of this is that he is acting rationally in his own best interest. If I have a client who says, look, I want to plead guilty because the food is better in the prison system and I just want to get out of here. I don't know. Is he acting in his own best interest in a short-term situation? I think there's certainly, one can argue that someone who says, I'm in the hole, it's so insufferable, which can cause mental distress. Isolation can certainly cause mental distress, Your Honor. It's so insufferable, I want to plead guilty so I go to prison for the rest of my life. I think there does become a disconnect. Where do we say that pleading guilty to go to prison for your life, the rest of your life, balances what the harm that you're saying exists? And in this case, I think that's a serious question.
Isn't the standard for competency, at least back then, was able to assist in your defense and understand the nature of the charges? I mean, that's pretty much it, isn't it?
Yes, but if you're saying, I don't want to put on a defense because I just want to plead guilty and get it over with, because I'm in solitary and it's insufferable, I think you are not assisting your own defense. I think it at least raises some serious questions, Your Honor, that
But that's not the standard, that the defendant must assist with their defense. It's be mentally capable of doing so. And we allow people to make their own choices. And if they choose to get out of solitary and plead, being shrewd enough to know the writing on the wall, he knew what the facts of the case were, that sort of thing. We allow people to do that. And we've got a report that said he was incompetent, or he was competent to help assist with the trial. That's also competent to enter a plea and make that choice.
yes, Your Honor. And if a court had had a hearing, and reviewed this, and perhaps questioned the defendant, or even didn't, then we could go forward and say, all right, we may question this, that he's pleading guilty for this reason, but he's competent to do so. But that never happened. All I'm trying to impress on the court is the fact that, for me at least, and I would think for any defense attorney, that's a red flag. It's a red flag that he was self-medicating with Prozac. Now suddenly didn't have it. He was taking no medications at the time. I think those are concerns and that's why we have a hearing. That's why this report, just in and of itself, is not enough.
So the bottom line problem is the record doesn't indicate that the court ever accepted this as a bona fide report or accepted the results.
Record doesn't even say the court ever read it.
Okay.
Or defense attorney, for that matter. I mean, we assume that's the case, but there's nothing in the record that shows that. And again, when we look after the fact of what happened in September of 2010, the court heard evidence, the court then had this report, but the court didn't have the defendant present.
Counsel, I'd like to address the procedural vehicle for us to be here, whether this is an appropriate motion for a legal sentence.
Yes.
As I understand it, you're arguing that the court lacked jurisdiction, and that's the grounds for it being an illegal sentence.
Yes.
How can that be if our case law allows that retroactive competency hearing?
It allows it, and I understand, Your Honor, and I think that's this court followed in Davis the McGregor analysis of that, and I agree that's sort of a disconnect, but I'm arguing it. Justice Beyer wrote the Murray opinion in 2012, and I quote, "Failure to suspend prosecution until it's decided that the defendant is competent to stand trial deprives the district court of jurisdiction for trial and sentencing." And that's basically a quote from Davis. So this court has repeatedly said, yes, it's a deprivation of jurisdiction. And in both Davis, which reversed, and Murray, which was remanded to determine if there had been any kind of competency proceeding or report, the court said that a motion to correct the illegal sentence was correct. So Mr. Ford is here on the same grounds that Mr. Davis and Mr. Murray. I do agree with Your Honor. How can we correct that retroactively? I suppose it's kind of a middle ground, and I certainly wouldn't object if this court said, you can't correct this retroactively. I submit in this case you can't, because when you apply the Davis factors, it's just an impossibility at this point. Unless there are other questions, my time.
Any more questions? Thank you, counsel.
Thank you, Your Honor.
May it please the court, the state appears by Stephen Obermeyer. I'll address the sufficiency of evidence as to the competency issue, and then discuss the motion to correct sentence statute and State versus Davis. As I read the testimony at the hearing, the attorney, who's now a district court judge for Mr. Ford, wanted an evaluation because of the insistence of the mother that if you're charged with killing somebody in Johnson County and also in Missouri with killing somebody, maybe he should be checked out. And he did that out of an abundance of caution, and he kind of walked through the competency evaluation. As you look at the order, there's blanks as far as the date of the next hearing, and it's an agreed upon order so that the competency can be looked at. And counsel himself, who's seeing his client, did not have any concerns about his client's competency. But there's the competency evaluation that's done anyway. And as I read Dr. Rietz's competency evaluation, Mr. Ford reports no history of previous psychiatric hospitalizations or treatment. And it's in the appendix in the blue brief, but it sets out that he's overall competent to proceed with his case and stand trial if he should choose. He presents no evidence of a thought disorder or other psychotic process such as persecutory delusions, grandiosity, and auditory or visual hallucination. His thoughts are coherent, logical, and well organized. This person has a good grasp of the system and was deemed to be competent. And I think that defense counsel, as I recall, he testified that he saw the report and his practice would have been to either withdraw the motion to determine competency or that it would have been addressed at the waiver of the preliminary hearing. Because this case, I think, was on a track to be a plea, which it ended up doing in February. And unfortunately, there's not a transcript from that preliminary hearing back in.
There were 2 trial proceedings between November 19th, when the report was submitted, and the plea, which is a record. But there's 2 hearings. That one was a preliminary hearing or a waiver of preliminary hearing, and another was an arraignment, or do you know what the other?
Yes, there was a preliminary hearing about December 11th, I think, a waiver of preliminary hearing, and that's where the attorneys thought they would have addressed it. Back then, it would go to a different court for trial, so it went to arraignment a couple weeks later.
And that there's no court-reported record of that hearing, is that right?
Correct. I think there's just a journal entry of the arraignment. And from there, it went to a docket call in Judge Ruddick's court in January, I believe. After the briefs were filed, the court reporter, the chief court reporter, was able to locate the reporter notes from the one of the docket calls where it was set for a plea, and from the sentencing hearing that was held about a month or so after that.
But typically, those 2 court hearings are done with a court reporter and a record made. Is that?
Yes.
Back then, that typically would have happened.
Yes.
And what occurred here is there's just no one could find the court reporter's notes or the record from those hearings.
I requested hearings from all those hearings, transcripts from all those hearings, and I think the court reporter who looked filed something explaining that she could not find the notes from those December 1992 hearings, the waiver preliminary hearing and the arraignment, which was why a different court reporter, but she was able to find the transcript of the hearings in January, February, and March, which again demonstrate the fact that the defendant was aware of what he was charged with. He signed an initial to 3-page plea agreement and a 5-page factual statement as far as what happened. The factual statement included the fact that he had confessed to murdering the victim and is found in possession of his property and had pawned the property in Las Vegas. So, he's probably not thinking he's going to go anywhere following this as far as being outside of the prison system. In fact, he was asked at the hearing, do you understand you're going to spend the rest of your life in prison? And he understood that. And so if you look at Volume 6, the transcript of the plea hearing, it demonstrates a knowing and voluntary plea. So that's statements in the trial record. And then at sentencing, defense counsel kind of interjects when the court proceeds to impose a sentence because the court was going to, I don't know if the court was going to say premeditated murder, but the defendant, through his attorney, wanted to make sure the court knew that he was being sentenced for felony murder during the commission of the aggravated robbery as opposed to premeditated murder. So he has an awareness of what he is being sentenced for. And again, at the beginning of the hearing at sentencing, is there any lawful reason to impose sentence? You would think that defense counsel, who's with this client for all these hearings, would raise an issue if that was an issue. And in fact, I think the McGregor case or the cases say it's, defense counsel can raise the issue. And I think even in McGregor, defense counsel kept persisting that his client was not competent. And that didn't happen in this case, nor at the end of the plea hearing where the district judge, Ruddick, asked, I think 2 times, is there anything further by either party, anything else? And that doesn't happen.
Can defendant waive the competency hearing? I mean,
I
once the evaluation comes back, can the defendant waive the
Well,
competency hearing?
I think so. I think under the language of the statute, it says it shall be suspended. But I think you could waive a statutory right to a competency hearing. Just as I cited the cases that say a voluntary guilty plea can be a waiver of any defect or irregularity that occurred during the course of the proceedings. And so that I think that could be waived. It's a statutory
And so
right.
what you're saying is the declination to verbalize any lawful reason that the sentence couldn't be imposed was tantamount to waiving any defects prior to that?
I think that and the just the entry of the guilty plea. I mean, the district court didn't force the defendant to plead guilty to these charges and to proceed with sentencing. They came to the court and asked to accept this plea agreement, in return for which he would not get the death penalty in Missouri, which was on the table prior to the resolution of the case. But I think the no lawful reason can be a waiver, as well as the entry of the plea can be a waiver. And then the fourth factor is the availability of individuals who interacted with the defendant, and I think his attorney was most familiar with him as far as the attorney never having any doubt about his competency during the case. With regard to the motion to correct sentence, I did just point out that that statute passed in 1970. I don't think it's been amended since then, but it says, and it's in Article 35, which deals with motions for new trial, that says the court may correct an illegal sentence at any time. And there's a judicial gloss on what that means in State versus Thomas in 1986, and I think that was the first case that says, well, it means if we have a sentence imposed by a court without jurisdiction, or a sentence that's ambiguous or does not conform to the statutory provisions. And that case, it doesn't cite where that came from. It's just the law now. And I think for a collateral attack on your conviction, which this really is, that the motion to correct sentence statute wasn't the intent. Because if that were the case, then why would you have KSA 60, 1507 or 1501 or that? And there's not an issue in this case. There's no allegation that defense counsel was ineffective or incompetent in how he handled the case. So now we have this a court without imposed by a court without jurisdiction language, and I think probably the best example of a case like that is the State versus Breedlove case, because there you have a person who was a juvenile when he committed the crime in adult court, and so the district court could never have subject matter jurisdiction in that situation because Breedlove wasn't charged in juvenile court and then waived to adult court. That's what I think is a good example of a court not having jurisdiction. But I think in this case, the court would have jurisdiction to order a competency evaluation, and while it's pending, if different issues came up, as far as discovery issues or, I don't know, issues the defense counsel had, could the court not address those because, the proceedings are suspended? I think the court would have jurisdiction to hear the case. So that's the language in State versus Davis that I think the court should look at, and it's at page 175. And the two cases it cites for the proposition that a judgment rendered without jurisdiction is void are two cases where there's a lesser offense given that's not really a lesser offense. Or one of them's a greater offense is given, and the defendant's charged with a lesser offense. So I get that. There's no jurisdiction for that. But here, the court had a sitting district court judge had jurisdiction to hear the case and proceed with it. And I cited the State versus Hall case that says subject matter jurisdiction lies in the district court from arrest throughout preliminary hearing, arraignment, and trial. So the court maintains jurisdiction. The other part about Davis that I would point out, that in Davis, the failure to suspend proceedings was an issue because Davis's competency was in legitimate dispute. And I don't think that was the case here. I think it was a matter of convenience for defense counsel to get an evaluation.
Was that the district court's view when the court ordered the evaluation? This is just a convenience for the defendant?
Well, the court just signed off on the order. There was no hearing on that. It sounded like it was just kind of walked through. The attorney had the prosecutor sign off on the order and took it down to the judge who signed off on the order, and it got filed, and there wasn't a hearing. But I think that was just defense counsel's, from the tenor of his testimony was kind of where I was getting why he wanted to do a competency evaluation.
But that doesn't explain why the judge signed an order for the evaluation, other than your view, which is he didn't really consider it, he just signed it.
Well, I guess if the judge wanted to not sign an agreed upon order, the judge could have done that, but it sounded like the defense attorney said, in 24 years, the prosecutor's always signed off on these, and the prosecutor testified that kind of in her role as a minister of justice, she thought it would be fair to sign off on it. And the judge, I guess the judge could have had a hearing and wanted some basis for it, but at least you have the explanation as to why the motion was sought in the first place, and it wasn't because the attorney had any concerns with Ford and his behavior. And so that's...
Excuse me, counsel. It really isn't fair, though, to try to make those points. Don't we have to take the court's order just at face value, that there's possibly something here, and so now what's the next shoe to fall? I don't think we can get much mileage out of whether the court had its heart into signing the motion or whether the defense counsel had his heart into it. I think we just have to accept it. I've been trying to wrestle with the fact that there's a plea hearing in between all of this, and it strikes me, and maybe this is a question for both of you, but it strikes me that and I understand the process, but as a practical matter, isn't that sort of an intervening event? The courts, is there a practical difference between the responsibility on the court to accept that plea and to make sure that the defendant knows what they're doing and is competent to do it and not being coerced? Is there really a practical difference between that exercise and what has to happen to determine whether the defendant's competent to stand trial?
I don't think there is much of a practical difference between making sure that a plea is knowingly and voluntarily entered into and having a competency hearing. you know, it was almost like a de facto competency evaluation. But because the court has to make sure that there's a knowing and understanding waiver of rights, that you have a right to confront witnesses and subpoena witnesses and testify. And the court went through all that and asked a series of questions of the defendant.
And so you're saying if a defendant doesn't meet the definition of being competent to stand trial, then that defendant is incapable of entering a knowing and voluntary plea?
If the defendant does not meet?
If the defendant does not meet the definition of being competent to stand trial,
Okay.
then you're saying that that person also is precluded from making a knowing and voluntary plea.
If they would not be competent to stand trial,
Then the judge, by definition, would be incapable of finding a knowing and voluntary plea because they wouldn't have the competency to do that. Is that your argument? I'm trying to clarify what's on the table.
I think I'm trying to argue that at the plea hearing, the judge and counsel got to size up the defendant and ask a series of questions.
I'm talking about the legal determinations that the judge has to make in order to accept a plea. And are they so different than the determination the judge has to make to determine whether the defendant is competent to stand trial that one doesn't affect the other, or are they so intertwined and tantamount to the same thing that it effectively takes care of the problem with not ruling on the evaluation?
I think it's effectively the same thing that would take care of there not being a transcript of a ruling on the evaluation. And the cases seem to say that as far as a knowing and voluntary waiver waives any defects that had occurred previously.
I'm not talking about the defendant waiving the defects. I'm asking if you're trying to argue that the ruling that this defendant made a knowing and voluntary plea, and I accepted the plea because it is knowing and voluntary, was tantamount to also saying that that defendant had the competency to stand trial because he or she made a knowing and voluntary plea. That the capacity you have to make a knowing and voluntary plea is equivalent to the capacity you have to be competent to stand trial.
I guess it would be the same, just kind of, I guess so. But, and the record does show that there is a lengthy discussion on the plea hearing, but.
To put that position in a little different posture, looking at the statute that, at least on its face, was complied with, 223201, it says that if the judge before whom the case is pending finds that there is reason to believe the defendant is incompetent to stand trial, the proceedings shall be suspended and hearing conducted to determine competency of the defendant. And it suggests by the next language, if the defendant is found to be competent, the proceedings which have been suspended shall be resumed. It suggests by its absence that if there is no finding of competence, then you don't resume the proceedings. So to look at this case, it appears as though the motion was made by a party, signed off by the prosecutor, and the judge then made a determination that there is reason to believe the defendant is incompetent to stand trial, and the proceedings were suspended, and then this competency evaluation was performed, which apparently, as I understand it, nobody really knew about that at the time or acted on it, because there's just an absence in the record. But at some time after that evaluation, while the defendant's competency is in doubt, the judge went ahead and went through this colloquy with the defendant and accepted the plea. So my question is it your view that that determination by the judge at the plea hearing trumps what's required by the statute?
I think the defendant can waive his right to a competency hearing or withdraw his motion to determine competency, which I think was defense counsel's practice.
But here, there's no record that that happened. The evaluation was performed, as I understand it. So, as I understand your position, because this person's competency was in doubt and the judge signed off, basically saying, yes, it's in doubt, that the judge later, without even re-examining that question, has determined that this plea was voluntarily given. So at some point, does the judge not have to determine he is competent to have entered this plea? Because on the record that we saw at this point, people were doubting whether he was competent. So my question is, how can somebody of doubtful competence enter a plea voluntarily, knowingly, without the judge making any kind of a specific determination on that point?
I think the colloquy at the plea hearing to make sure it's a knowing and voluntary plea could be a waiver of the order or the competency evaluation, and I guess it would be kind of like the situation in the Burigi case where there was a competency evaluation ordered. There wasn't one in Davis, so that's the X factor. We don't know what it would have said. Here we know what it would have said, that he was competent, and that the parties proceeded to ask the court to proceed with a plea hearing so that it's either an invited error or doesn't violate substantial justice under KSA 6261, that it's kind of a harmless error by not following the language of the statute. And just remember that Davis came out in 2008, I believe, and back in 1993, the attorneys did not have any idea about this Davis case. And you did have defense counsel saying that his practice would have been to either withdraw the motion or to address it at the next hearing. And unfortunately, we don't have a transcript that shows that was addressed. But I think the proceeding forward with a 3-page plea agreement, a 5-page statement of facts being initialed is a waiver of that challenge, and that it's not reversible error.
So it's a waiver by somebody of questionable competence. Is it not?
I just don't see it as that he was not competent. I mean, I know the order was signed.
Well, what's the purpose behind the statute when it says shall suspend the proceedings once these steps have been followed? What's the legislature attempting to do by telling us that's what's going to happen?
Right, that there shouldn't be any additional hearings until we get a competency evaluation and a ruling on it. And we got the competency evaluation in short order. We just don't have the transcript of what happened at the next hearing. And the prosecutor thought it was discussed. Defense counsel said, I would have either withdrawn the motion for competency or it would have been discussed. But 18 years later, could not remember which approach that it was. So I think they thought it was addressed. If it wasn't addressed, the proceeding with the plea agreement and the sentencing and defense counsel not raising the issue ever again would militate against the concern that somebody incompetent is going to plead or to trial. And the other thing, after they're committed, used to be an SRDC report by the State Reception and Diagnostic Center. And I'm sure if there was a report that was bad in that situation, that we would have heard about it. And that didn't happen in this case either.
Was it a pre-guideline case?
Yes, this was a pre-guideline case. And also the pre-sentence reports back then were not in the court file, nor were the competency evaluations.
Is it Mr. Nay's point that the possibility of the 2010 hearing being a retrospective hearing in determining competency, does Mr. Ford need to be present for the 2010 hearing? That's his point.
I don't know if he needed to be. I don't know if the retrospective competency discussion in McGregor really discussed whether or not had to be present or not. That issue really was raised for the first time this morning, but I think defense counsel's approach at that 2010 hearing was that this is a documentary hearing. Initially, they didn't think there was any evaluation, and then there was one done.
But okay, thank you.
And what is the effect of that 2010 hearing, assuming that we would say it was a valid retrospective competency? Does that then just validate everything that went forward, or does that mean that we put that back into the procedural flow where it would have fit and start over there? In other words, it would have been the first hearing after the competency evaluation, and then everything else, like the waiver of preliminary hearing, the plea, still have to occur? Or how do we validate what happened?
I think the effect of the retroactive competency hearing would be to say that if there had been one, this is what the result would have been, so that you don't have to set aside the plea or the sentencing or the arraignment or the preliminary hearing. That's what I think.
Any further questions? Any further presentation?
I would just ask you to affirm Judge Ruddick's finding that it was that he was competent and voluntary and knowingly entered a plea.
Thank you, counsel.
May it please the court to answer some of the court's questions. Can it be waived? No. Statute specifically says you can't waive it. It says the court shall conduct a hearing once the competency issue is raised. It can't be waived. I'm not sure it can be withdrawn once the issue is joined. We have a situation where the state is saying, well, defense counsel didn't raise this again, so it's waived. Well, in Murray, they went through trial, it was never raised again. In Davis, it was never raised again. That's the whole point, isn't it? In other words, Davis and Murray are meaningless because they can't apply to any case because counsel didn't raise it again. That is not a waiver, the lack of raising it. The discussion about whether a plea can be knowing and voluntary, well, the problem is you can't have a plea at all, voluntary or involuntary, while a defendant remains without a finding of competency, while the case is under suspension. So we can't even get to that question, in my opinion. And to say that someone can say yes, no, yes, correct. I mean, look at the plea colloquy. Again, longest answer, 4 words. No, I did not. There was no real discussion with him. I've had clients who could get through that, although they believe that the judge is Satan trying to take away his soul, but could say yes and no to questions. That doesn't make him competent to enter that plea. And that's the first determination Not whether, retroactively, we can say the fact he took a plea makes him competent. I mean, that just absolves the system of any kind of follow-through on the evaluation. Again, harmless error was discussed. This court specifically rejected harmless error both in Davis and Murray. And in fact, in Murray, it said if there wasn't a competency evaluation, it was remanded for that we reverse. It must be reversed. There was no question about evaluating the harmlessness of the error. And the defendant must be present. You cannot have a hearing. Both the statute says that, and did at the time, and if this is not a critical stage, I don't know what is. To find your competency to move forward. So to say that something happened in 2010 that had any meaning without the defendant's presence and ability to contribute, I just say is an illusion. Finally, we talk about this evaluation, but an evaluation is just that. It is not the finding. We don't know what would have happened had the judge looked at this, had counsel looked at it, and had a hearing. We're saying maybe, perhaps, no one has specific recollection, we talked about it or we didn't. That's not the kind of record we can proceed on. I've never been able to proceed under that kind of record. Well, yeah, there was an objection, it's not in the record, but everyone sort of understood there was an objection. No. There is no record here. No one has any even recollection that this happened. We're asking the court to follow its precedent in Davis and Murray and reverse this case. Again, retroactive competency hearings have not been favored as this court said in Davis. Retrospective competency hearings are generally disfavored, but are permissible.
And your remedy is to reverse and remand for further proceedings from the point that there should have been a competency hearing.
Yes.
As Justice Luker was saying, so that it could go forward if they could establish retroactive competency at that point and then proceed to trial, or are you asking for an outright reversal?
Well, it should be reversed, and then it can be proceeded if the defendant is competent to stand trial. And then a trial take place or whatever would happen. That's exactly the remedy that was assigned in Davis and exactly the remedy that the court said would be applied in Murray if there wasn't a competency. If there are no further questions, submit the case.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.